रिप्लाई फाइल करने के लिए खुद ही ड्राफ्ट करना पड़ता है, खुद ही पॉइंट सारे लिखने पड़ते हैं, ये कुछ ना कुछ फाइल करते रहते हैं। इनका टीम ऑफ लॉयर्स है। जज साहब प्लीज इसमें कोई भी अर्जेंसी नहीं है, मुझे 2 months का टाइम दीजिए।
The son is with whom?
Lord, the son is mine and he is with me. He's not her son. It's from a previous marriage. He's autistic. I need to make, because my main asset was the flat which she's occupying. I'm not disturbing.
अच्छा, मैं डीवी ऑर्डर से रह रही हूँ। ये मुझ पे केस फाइल करते हैं और मुझे हर चीज में मैं पार्टी पर्सन हूँ, मुझे रिप्लाई फाइल करने के लिए भी टाइम चाहिए। इनका टीम ऑफ लॉयर्स है, यही करते रहते हैं।
Pleadings are complete. So, Malad,
जज साहब मैंने रिप्लाई भी फाइल नहीं किया है, मुझे 2 months का टाइम भी चाहिए से देने के लिए। ये कुछ ना कुछ फाइल करते रहते हैं। मैं पार्टी इन पर्सन हूँ जज साहब।
How can you oppose for a listing, madam?
प्लीज 2 months का टाइम दे दीजिए, 2 months का टाइम दे दीजिए जज साहब प्लीज।
एक तरफ लोग बोलते रहते कि तारीख की है वो तारीख मिलती रहती है और आप 2 महीने का टाइम।
मैं मुंबई में रहती हूँ जज साहब, मैं मुंबई में रहती हूँ। ये दिल्ली में लिस्टिंग करा रहे हैं।
बॉम्बे से ऑनलाइन ज्वाइन हो जाइए आप यहाँ मत आइए आप।
प्लीज थोड़ा टाइम दे दीजिए जज साहब।
ठीक है, 2 हफ्ते के बाद आफ्टर 2 weeks 2 हफ्ते में दाखिल कीजिए आप रिप्लाई।
जज साहब मैंने अभी बनाया नहीं है, मुझे 4 weeks का टाइम कम से कम दीजिए। मैं पार्टी इन पर्सन हूँ।
उनकी गलती नहीं है, आप अगर 4 महीने नहीं बनाएंगे तो
जज साहब मुझे 4 weeks का मिनिमम टाइम दे दीजिए। 4 weeks चाहिए मुझे जज साहब, मैं पार्टी इन पर्सन हूँ।
Fixed date, Malad.
2 हफ्ते के बाद फिक्स डेट दे देना।
पार्टी इन पर्सन
8.3 Malad, sir. It is showing the advanced list for tomorrow, Malad, sir. Top of the board, but
Is it listed tomorrow? Next week?
next Tuesday, Malad, sir.
High on board, we have already kept so many matters high on board, so we don't know.
Malad, sir, on the previous occasion, your lordship said heard a matter on the 1st of April. Your lordship said that it may be listed on a non-miscellaneous date because it requires to be heard. Your lordship may say that it come up high on the board, otherwise, Malad, it's getting listed on previous.
What is it about?
That's a remand back matter. Your lordship said granted leave in the matter, and then again the High Court has passed the same order against which we came in SLP. Lordships have protected us by an interim order, but that was last year, Malad.
But if you already protected, then what is the urgency?
Malad, that matter has to be decided, Malad. It's a question of identity of the property, Malad. That is the only issue in current.
ठीक है, 2 हफ्ते के बाद।
Oblige.
May I speak, Your Lordship? Your Lordship, on yesterday, there is a news article in Express, Your Lordship, about this Honorable Court and the Honorable Chief Justice of India, Your Lordship. About this Honorable Court and the Chief Justice of India, Your Lordship, by the Nishikant Dubey, Member of Parliament, Your Lordship. This is the.
So what do you want?
Your Lordship, I want to file a contempt petition with the permission of Your Lordship.
You file it. For filing, you don't require our permission. You will have to either get a sanction from the Honorable Learned Attorney General.
Please, Your Lordship.
Lordship, I'm seeking a kind indulgence in a matter which is coming up tomorrow. My Lordship, it was shown for listing tomorrow. It is coming up tomorrow, but only one IA is being coming up, my Lordship. I am requesting IA for direction, which is IA 6 of 16, which is the main IA in the matter. The decree has been pending since 2002, my Lords. This honorable courts are not being, order are not being complied with by Your Lordship.
But what is it about?
My Lord, is construction of SYL canal, my Lord. This is the canal which will bring lifeline to state of Haryana to bring water, my Lord. The decree was passed in 2002 and then specific directions in 2004 were passed by this honorable court. And then the matter has been lingering on for one reason or another, my Lord. Only the IA for direction.
After 2 weeks.
It's coming up tomorrow, my Lord.
ठीक है, उसके साथ लगा दीजिए।
Grateful.
Lordship, kind permission to mention.
I mentioned a matter coming up on 30th of this month. I'm requesting not to be deleted, my Lord.
May I seek Lordship's kind permission to mention, my Lords, in tomorrow's list, item 42, my Lords, it pertains to imposition of President rule in the state of West Bengal. My Lord, that petition is filed by me. In that petition, my Lords, I have filed IA for directions and implement, bringing out certain more incidents of violence which have happened in the state of West Bengal, and paramilitary force and immediate action is required. Lordship, I am only requesting that.
So what you want us to issue a writ of mandamus directing the union government to.
I am explaining. Article 355, Lordships can call a report as to what is happening in the state, and then Lordships can move ahead. Already notice has been issued in item 42, which is listed tomorrow. I am only seeking.
As it is, we are alleged of encroaching upon the
It is,
parliamentary and executive functions. So
Lords, when the matter will come, Lords, I will demonstrate that how the violence is happening. I am only listing my implement application and direction may be listed. I filed. I am great.
May I mention a matter which is coming up on 23rd, item number 40. This is that whether IDBI is safe within the meaning of Article 12. Your Lordships had given us time till 15 to circulate our list of submissions. There's some delay on our part. I'm seeking permission to circulate.
Your Lordship's permission. Your Lordship, this matter was listed before Your Lordships on 17th of March. Your Lordships have granted stay subject to deposit of 30 lakhs. Your Lordship, 4 weeks expired on 14th of April, Your Lordships, and 11th to 14th were declared as holidays. I am requesting the permission, Your Lordships, to file the DD. Deeply obliged.
Your Lordship were extremely gracious to allow the matters for tomorrow not to be deleted, Manoj, so they're coming tomorrow. They're coming tomorrow, Manoj, by your Lordship's graciousness not to be deleted. Manoj, they're showing us item 38. And this would be the 6th listing in the last year and a half, Manoj, when matters are listed. But if your Lordship could consider a fixed time, Manoj, with a 94-year-old gentleman wants to come in person to address your Lordships. So he has his own medical constraints, Manoj, to come at 10:30 and then wait for it to be called to be a little difficult.
But he did not come. You can argue for him.
I've explained to him, Manoj, but he wants to express his views in a particular matter.
We'll see tomorrow. Get the other side. You get the other side tomorrow and mention it.
For a fixed time?
So
It's already listed.
it's already listed. If you want it to be taken on a fixed time, to get Mr. Savla and mention it in the morning.
Very good.
Towards item 1 for petitioner. Here already four cases are pending before the court in Gautam Budh Nagar, and they have filed a section 13 petition before Haryana court. So it is a transfer petition from Haryana.
So mediation has failed. Who is for the other side?
I appear for the respondent in this matter, Milas.
Yes.
Milas, I have only 2 grounds, Milas, in this, Milas. One is, Milas, that they have sought a transfer of the HMA filed by the husband, Milas, from Gurgaon to Noida, Milas. Milas, the distance is not more than 52 kilometers, Milas. Milas, she is a working independent woman and she has been going to the office as well. Milas, before marriage also, she was working in Noida, and she has been appearing there, Milas. She has filed a reply there. So, Milas, any which way she has to. Any which way, Milas, she has to appear in Gurgaon courts, and Milas, both the matters may hold simultaneously, Milas. So, Milas, there is no point of getting it transferred from Gurgaon to Gautam Budh Nagar. Milas,
The application is vehemently opposed by the learned counsel.
That will be considered for
1 minute. When we have started dictating, should have some restraint. The application is vehemently opposed by the learned counsel of the respondent. However, taking into consideration the facts and circumstances, we are inclined to allow the application. However, the respondent would be at liberty to appear through video conference. We have some patience.
Please, Your Lordship. Charge sheet. I'm for the petition, Your Lordship. Your Lordship, charge sheet has been filed.
Yes, because I strongly object. My vehement objection.
In Antigua, the learned, you're you're also your additional advocate general or only senior counsel?
This is for the state, Milas.
The learned senior counsel appearing for the state vehemently opposes the application. I will take into consideration that pursuant to the interim orders passed by this court, the petitioner has not only joined the investigation, but charge sheet is also filed. That we have the matter, we are inclined to allow the application. The order is expired. Stands confirmed.
Yes, the service is complete. I think on the complainant.
So duly served non-appears for R2.
Plus, he may cooperate.
Now after charge sheet, what cooperation?
Yes, my lords. Also, the presentation, petitioner is in custody since 5th of February 2023, approximately 2 years and 4 months. That's no other FIA. Plus, the present case, the total dispute was around 21 lakhs, out of which 5.73 lakhs has already been returned to the complainant.
Yes,
But this is chit fund fraud.
Yes, but he has been inside for more than 2 years, so.
But total amount is 1.84 crore. They should better settle not with all these investors. These are ladies.
We can't impose a condition for settlement for grant of bail.
17 investors.
Correct. The application is vehemently opposed by the learned counsel. For taking into consideration that the petitioner has been incarcerated for a period of more than 2 years and that the trial is not likely to conclude in the near future, we are inclined to allow the plea.
But we are requested to inform the trial court before leaving the country, because there might be a flight risk. One condition.
Correct. We direct that. In addition to the condition that the learned trial court may deem it appropriate, impose one additional condition. We propose impose one additional condition. Paragraph. The applicant shall deposit his passport with the learned trial judge and as and when he intends to travel out of India, he shall do so only after obtaining the permission of the learned trial judge.
Great.
After notice matter, my lord, last time my lord directed to conclude the trial within 1 year. Last year, January, page 75 dot. Thereafter, prosecution took at least 13 dates where PWs did not appear. Page 88 onwards, 13 times, and thereafter, all the accused lawyer they appear.
Who is for the other side?
NCB is they sought time on the last occasion for 88 onwards, at least 14-15 dates.
काउंटर नहीं आया स्टेट को
But Joshi, nobody appearing for Union of India. Nobody is appearing, Mr. Joshi. Nobody is appearing for Union of India.
I'll inform us. I'll take the details.
Next Monday.
I have it next week.
Instead of English Vernon appears for Union of India in order to give one more opportunity to the respondent Union of India. Stand up to next Monday.
I'm seeking a passover of 10 minutes, Lordship. The main counsel, Army counsel is coming.
We will grant you bail as and when you have a ready donor.
Sorry, Lordship, I'm not having any instructions. There's just 10 minutes passport.
What is this 10 minutes passport and 5 minutes passport?
Just, he's coming, Lordship.
Yes, my lord. My lord, I am in custody since around 4 years, and 27 times my bail application has been listed before the Honorable High Court of Allahabad at Allahabad. And your lordship, there is since 2 years my bail application is pending. Lordship, in paragraph number 4, the imperative direction has been given. In paragraph 4,
Whether the complainant's evidence is recorded?
no, that will be the second round, your lordship. First round, the imperative direction has been given that the charges had to frame, then charges have to frame. And consequently, the charges has been framed. I had asked in the court without any counseling, the charges has been framed, your lordship. That time only. No counsel was there, your lordship. And even I was ready.
No, it is observed that
I could mandated, your lordship, paragraph number 4.
whether complaint's statement is recorded or not.
Not right now, reported it.
You have been inside for how long?
More than 4 years, around 4 years, lordship.
Almost 4 years. Complainant's evidence will. Normally would not have entertained the petition. Since the matter is already pending before the High Court. However, take into consideration that the petitioner has been incarcerated for a period of more than 4 years. And further that the bail application was adjourned 12 times.
27 times.
This application.
This application, Your Lordship, kindly come on the page number 65. I have given.
And that the application was adjourned for on 27 occasions. We are inclined to issue notice returnable 3 weeks.
Because this is a matter of a civil dispute and charges have been framed. And when that opportunity is not given to me, that Honorable High Court mandated that charges has to frame, and consequently trial court has been framed.
We have already issued the notice. You don't want this.
Because by law there will be complaint of obliged lords.
We can't grant without hearing them.
Obliged lords.
Whether the petitioners have been falsely implicated under false, imaginary, and pre-well planned story of the complainant, my lord. My lord, there is a delay of 18 hours in lodging the FIR without any valid explanation, which is fatal to the prosecution, my lord. The FIR without any proper inquiry, without any proper investigation, police registered the FIR without conducting the preliminary inquiry, my lord, despite the nature of
Whether it's such sort of allegations.
my lord, it occurred due to
No,
the
you have forcibly entered somebody's house, molested a 13-year-old daughter.
No, my lord. My lord, may kindly consider he is staying as a servant in the landlord's home, and there is a dispute between the landlord and the petitioners, my lord. There is a rivalry between the landlord and the petitioner, and it is a pre-planned.
Have you filed any previous complaint against the landlord?
No, my lord.
Then
My lord, may kindly consider.
one can.
My lord, on perusal of the FIR prosecution story and even statement of the victim, my lord, there is not even a single word stated against the caste. Atrocities Act has been.
Let us see the FIR.
Sorry, my lord.
Let us see the FIR.
FIR is on page number 24, my lord. May I read, my lord? Page number 28. My lord, this is a false allegations, my lord. Atrocities Act, there is not even a single word uttered against the caste of the victim, my lord. And my lord, there was an election. The police were on patrolling on 19th of September, my lord, 19th of November. So there is no chance, my lord, that petitioners would have entered the home. And it is said in the FIR and reply filed by the state, my lord, that the home was locked. My lord, may kindly consider.
Sorry, we have to go at the face value.
My lord,
Therefore, we ask you whether there is any previous complaint. Is there any previous complaint?
That I have to find out, my lord.
Find out.
I have to take instructions, my lord, about the previous complaint. But my lord, when the incident occurred, even mother and along with 3 children were there in the home. And it is said that they stay in a single room home. How is this possible, my lord, that the victim, the culprits goes there and...
That we don't know. We can't.
They are unaware, the mother is unaware.
We can't go as to whether the allegations in the FIR are true or false at this stage, madam.
Consider the story, my lord, which is completely...
Sorry, madam. Thank you.
My lord,
Thank you.
can you grant me some time then to file the instructions, to take the instructions whether...
The learned counsel of the petitioner submit that there is a previous enmity between the petitioner and the complainant. 6, how much time?
2 weeks time, my lord.
2 weeks time. Place on record any documents in support of the said condition. Show us any previous complaint or something of that sort. Then we'll consider.
Yes, sir.
2 weeks.
Highly obliged.
How can such a relief be granted in a modification application?
Please, Madam.
Nature of review. The application is in the nature of seeking review of the order.
Yes, my lord.
And how is it possible? We have dismissed such petitions with exemplary cause.
My lord, with regard to the SLB, my lord, in 8382 of 2022, it was disposed and this honorable court has remanded the matter to the High Court.
Yes, and what has happened to the revision?
That matter was still stating proceeding, my lord. The proceedings are happening still.
Go and proceed with that.
While inspecting the file and all, my lord, I would like to bring to this honorable court that I found so many erroneous proceedings, in the SLP. I would like to bring to the notice of this court.
And we were heard when the matter was
Yes, Madam.
Yes,
Yes,
my lord.
Madam.
Yes, my lord, but the orders were suppressed before this honorable court.
Okay, thank you. The present application.
My lord,
Seeking
just give me one opportunity to just submit my.
Firstly, your application is itself not tenable. You can't seek a review of the order under the garb of modification. And secondly, you were heard when the matter was.
My lord,
When an order was passed and you are coming after now 3 years.
yes, Madam. Lord, I don't mean to interrupt, my lord. In fact, my learned friend was.
2023, my lord. In 2023, my lord. In November, I filed this.
2 of the judges have already retired.
But, my lord, they have done the fraud in this court, my lord. They have suppressed
This is.
the order by this court.
The relief claimed in the modification application, which is almost seeking a review of the order, cannot be granted. Such a proceeding. Rejected.
Obliged.
Notice tag. Okay, sir. Same order करना उसमें जो wait leave granted tag with the connected manager.
My laws kindly grant a passover.
I'm 49 requesting for Passover. I'm requesting for a Passover.
Rejected. If you can't understand what we are saying, we can't help your client. How can we pass an order clarifying that the party was not a party to the petition, it is deemed to be a party?
Only submission that.
Therefore, we had advised you file a contempt against the state and the collector.
May grant me permission to file the contempt against the appropriate.
For that, you don't require permission. We will grant you liberty.
Liberty, Your Lordship,
The petitioner seeks liberty to withdraw the application with liberty to file a contempt petition.
Lordship, only that
Now, don't say only.
the appellant number 1 had died. So I have moved an application for that. Permission may be granted. Please.
Please, my lords. Here, my lords, my land was given by a court decree. I point out the court decree. I point out your lordships.
Why don't you go to the High Court? We go on entertaining every petition here.
The reason is this. Your lordships has already issued notice in 2 other matters, Asmat
Yes.
Lisa and Kitab.
Because we want to, as a test case,
I appreciate that, and I anticipated the question.
Otherwise,
But
here it will not come up even after a year. In the High Court,
with respect, my lords, let me take my chances. May I just tell your lordships why I think it may be a better idea here. Your lordships, the other matter, Azmatun Nisa, is coming up on the 27th and 28th. Your lordships may have this also along with that, because the facts are almost identical.
yes, but the respondents will be different in that matter.
I will serve them thusly. Here, I show them this is a court order. After the court order, I have paid the money. Here is the hard copy. My lawyer here has given them a notice on the previous evening itself, pointing out all the facts. And despite that, if the collector refuses, and my lord, sometimes collectors are young people, hot-blooded. And there are times, my lords, where mere going to the High Court may not be sufficient. If your lordship just asks them to explain their conduct.
High Court jurisdiction is wider than our jurisdiction.
If your lordships ask them to explain their conduct, it will be, my lords. Please, with Azmatun Nisa, this is Pukhraj. My lords, the point is that the contagion seems to be spreading. That irrespective of what we do, what our efforts are, they sometimes seem to think, my lords knows in English poetry, there's a phrase called written water. It's almost like that we keep banging our heads and saying that, look here, if your lordships could kindly consider.
Issue notice. Returnable 4 weeks.
I will serve thusly.
Thusly permitted.
Status quo today, as on today.
You are saying it is already demolished?
It's been demolished, but what's happening is that the neighboring veterinary college wants to build on it or take it over. That's the real problem. Please, status quo as on today.
Declared them as party respondent.
Yes. Yes.
Thusly permitted.
Please, my lords, item 19, my lords, the petitioner has suffered from the adverse effects of immunization after taking the first dose of COVID. My lords, he seeks
How can a writ petition be filed for that?
My lords, there are
File a suit for damages.
My lords, there are already 2 writ petitions which are pending, my lords. Notice has been issued by coordinate benches of my lords. Wherein, my lords, the respondents, my lords, have been asked to answer. These people, my lords, and here he has suffered from 100% lower limb disability, my lords.
Where are those notices?
Please, my lords. My lords, we have mentioned that my lords, one of them is here. The other one, my lords, has been passed on the 5th of March, my lords. This is the lead matter, my lords. His right to live with dignity, my lords, as a physically handicapped person.
Yes, sir, you are yourself, if you keep the petition pending here, nothing will happen for 10 years. At least if you file a suit, you will get some quick relief. If you want, we will just tag it along with this.
Will be grateful. I shall be grateful, members, because
You shall be grateful,
this is
but
exactly what
your client will never be grateful to you. He will only have a hope that the matter is pending here, and for 10 years, it will not see the light of the day.
My lords may then grant me a week's time, my lords. May I revert back, my lords, after just discussing with the clients, my lords. I shall be grateful.
At least the suit is filed within 1 year, 2 years, 3 years, you will get some
My lord.
amount.
My lord, I had informed him, but I would request my lords to just grant me a week's accommodation. Grateful, my lords.
Similar matters have been discussed.
Already discussed. Thank you. Delay Kandu.
21 first. May I just give the brief background, your lordships. This is the second time this matter is coming before your lordships. Lordships permitted me to assail the order of contempt, Lord, and I had challenged the order of the division bench. Lords,
What is the purpose of grant of compassionate appointment?
Because there are two orders of.
No.
17 years have passed, Lord. No fault of me, Lord. Still,
So what is the purpose of the compassionate appointment?
to survive, Lord, of course, your lordships.
To beat the situation of distress.
Yes, Lord.
So whether that condition
Plus
continues for 17 years.
Here I am before your lordships for the disobedience of the orders. Twice, Lord. Honorable High Court.
I could only direct it to decide your representation.
Plus thereafter, Honorable High Court directed to decide the writ appeal, my lord, and the writ court, intra-court. Both the courts said, my lord, that my case should be considered by the department, my lord. Department, instead of considering it, the order says two parts. One, 10,000 rupees for the fault of just keeping the representation pending, cost the deposited, my lord. And the second part of that order was that since you have not considered it for so, you consider it. It is not that the writ court order passed on 13th August 2018 was challenged, set aside. Second, my lord, when I filed the contempt petition, during the pendency of contempt petition, when contempt notice was issued, my lord, at that point of time, my lord, the order was passed. And based on that, my lord, 12 July 2024, my lord, the contempt petition was dismissed. I challenged that before Honorable High Court only. Honorable High Court issued notice in contempt appeal, my lord. But in view of the DN Taneza matter, my lord, that contempt petition is not on merits, my lord, in view of the legal position, my lord. Then I came to your lordships. Your lordships permitted me to assail that order. That order I have placed on record, my lord. If the lordship would come to see the lordship's order only, let's kindly see page 61, my lord, for a moment. Page 61, my lord. If your lordships permit me, may I read, my lord? Learned Counsel for the petitioner seeks permission to withdraw the special petition with liberty to file a fresh application. And my lord, challenging the order of learned single judge. Permission granted, the special petition is received. Lord, the DN Taneja case, if your lordship would see, categorically says that the remedy is before your lordship. Because there was an inadvertent, it is not, notice was already issued by Honorable High Court. That order I have placed on record, my lord. It is not that the contempt, in contempt of your lord, if your lordship would see the order I have placed, lord, the page note 57 for a moment. The contempt court, while considering the plea of the petitioner, noted.
We are challenging contempt of order dated 31st of March 2022.
Yes, my lord.
Let us see that order.
Yes.
Page 23.
Yes. There is page 30, lord. Operative portion is at page 30. Thus, para 11 onwards. In the light of aforesaid judgment, the policy dated 30th January 1997 was neither withdrawn nor cancelled. It was only kept in abeyance. Therefore, the writ court has rightly directed for consideration of the case of the respondent number 1 for grant of compassionate appointment under the policy prevailing at the time.
Only consider it and you see para 12.
Whereas the 13th para, my lord, there is lordship, the last para, operative portion, my lord, the cause for delay in not considering the case of writ petitioner for 4 years.
Thank you. Dismiss.
The lords, one
Thank you.
Since your lordships, the single bench has permitted me to assel the order dated 8/6/2022. So one clarification with great respect.
No, if you want to.
That this order will not come
No.
into decide approaching to the court.
If you want to withdraw this.
I'm just saying that your lordship.
Thank you.
Page 3, my lord.
Thank you.
Only one line I would like.
Thank you.
Please, Your Lordship. My lord, my election has been challenged on the ground that I did not give certain information in Form 26. Your Lordship, 3 things I like to point out. The scrutiny takes place on 26th of April. No objection is raised by any of the candidates. No objection is raised by the RO. And there were 17 candidates. I had won the election by a margin of 18,000 votes. No candidate has challenged my election. Only some voter comes and says that you have not filled the form.
Sir, a voter is not permitted to file an election petition.
Please, Lordship, I'm sorry.
Under the representation of people I.
Yes, sir, that's right. I'm not saying that.
So.
I'm only making.
When will a voter get a chance? If he is not a candidate.
All right. Your Lordship, may see one thing. So far as the rejection of a nomination paper for want of certain information, Form 26 is concerned, it is covered by the judgment of this Honorable Court in Surgeons of India case. If Your Lordship may just have a look at that judgment. Supreme Court says that when you file the nomination paper, the returning officer will check them. If certain columns are unfilled, he will ask you to fill those columns. If you still don't fill it, can be rejected. In my case, I have placed the Form 26 on record. Your Lordship may have a look at that. No column has been left blank. All columns have been filled. The things that they are wanting is very interesting and very funny. They say, the petitioner says, you have not attached the election expenditure return with the nomination form. Well, the election expenditure return has to be filed after the election. Can we turn to page 96?
Not a case for interference. Thanks. Not a case for interference.
Well, then Your Lordship may permit me to withdraw, then I'll take all the objections.
Allowed to withdraw. Yes, notice that. Delay.
Poor payment for us. 89 notification, they are running from letter to.
Who not entitled to interest.
And 24 also the same, that's the timing.
Delay. दोनों में लिख लेना. Would not be entitled to interest from the village sale.
Please, my lords. My lords, we're only praying for very limited relief here. My lords will have the impugned order at page 2.
Page 2.
Page 2. And the second but last paragraph. On being asked from learned counsel for the applicant, whether the applicant at the time of his arrest by the respondent number 2 had shown the case law which has been relied in the present contempt application, he has submitted that it's not shown. We are only praying that this. I'm obliged, Raj.
Your Lordship had already.
Same order.
Same order.
Make please absolutely.
It will be covered by Lordship's judgment.
But then why you are not filing a application under 28A? For everything you have to come to the High Court.
They are very poor business and the consumption was such a minimal. And that they have been discarded to Lordship. And after a long time, there was nothing. Well, only one case which was raised from bottom up to your Lordship's Lord, then this question was settled. And otherwise, all representatives.
So therefore, but why you can take the benefit of this order and go under 28A?
The position is this, position is this, Lordship, right? I have no answer to what this query.
You have no answer because if a client comes and your awards can't say no.
My submission is Lordship, my submission is that they are the poor farmers, illiterate poor farmers, and their land is situated just adjacent to this mill. And they cried much, but they could not get anything. And here is by means of an order passed by the Lordship, a few of some generation injected in their mind, and they approached the Lordship under Article 32. And this is a position where the fundamental rights of any person is just going to peril. And if Lordship protects them, it is that case, it will come.
So therefore, we should now then close all civil courts, all district courts, and all high courts, and only entertain everything directly here.
If any way is provided, is given to me to approach the High Court, I can go there. But exactly.
Why this 28A? What is the purpose of 28A?
That one point exists. My submission is straight to under Article 226. I cannot approve for two reasons.
And you can approve here under Article 32.
What I submit here, but for the purpose, then the matter will go to reference court, and from reference against the order of reference court, the matter will come to the High Court.
And then again to the.
Then
why not we try all then the 302 matters directly here?
I will not have any answer to this except praying here.
Thank you.
Just can see.
Yes, better withdraw and go under 28A.
But then your saying at least give me pave the way so that I can approach the High Court again.
No, not High Court. 28A.
If 28A position is there, then at least this may be permitted.
The learned counsel was a petitioner. Seeks liberty to withdraw the petition with liberty to file an application under section 28 of the Land Acquisition Act 84. Pornographic. No.
On the basis, item 31 also, madam.
31.
The two matters. My lord, permission to serve standing counsel, madam.
Please. This, with the greatest respect,
State का अपनी डिफेंस कर रहा है.
this order is without jurisdiction because if the appeal is disposed of, and
What we are saying?
then imposing
Inherent jurisdiction, we can do anything under 142. So the High Courts can do anything under every.
It's in a
Notice.
and section 76.
Yes.
is a specific rule.
If they wanted, they should have filed an application for injunction before the trial court.
He did, and he lost.
The injunction is lost.
Yeah, injunction was left.
Would your lordship stay that?
They went to the company law board, they did not succeed. And my lords have held the criminal and civil can go on. And number two, there is an FSL report which the High Court has.
File your reply, notice stay.
My lords may issue notice, my lords.
You are issuing notice here.
My lords, the complaint is about 10 years back.
Stay throughout.
And
Nowadays, this trend is increasing. Everything, all civil proceedings are trying to be converted into criminal proceedings.
right in the beginning itself, I must point that out.
It is rejected to be cost. Now,
Let me put my response in. I'll put the date line also. I will put that I had issued public notices much before these complaints and this particular injury happened, that my documents had been lifted. Thereafter, these documents are presented. They are completely forged. There is an FSL report there.
leave granted.
My lords may not do that. My lords, please, my lords may not do that. I'll put my.
No, we don't appreciate these post-mortem arguments. We already issued notice. Whatever you want to say, you file your reply. Why should you argue after an order is passed? Every day we have to repeat that we never see such things in the High Courts.
Because we only try to pursue which are the final court that it.
No, so therefore,
That's why.
Yes, once you said that you will file reply, then you should argue after filing reply.
Lordship, 8.5 years of incarceration, my lord.
You have killed 4 persons in an indiscriminate firing.
Have PW1, my lord.
You will issue notice.
My lord, giving permission to serve the state.
Serve the standing counsel. That is our format of our order.
In all fairness, I must bring to your lordship's notice that in one case, your lordship have been pleased to dismiss the appeal, but only one aspect is there. Now, my lord, there are no.
Para 67, paragraph 65 and paragraph 67.
There are not one case. There were not 4 cases against him. Now, Lord, there are 3 more cases. Not 35, 35.
All of the बाकी तीनों बुला लो
35.2.
बाकी तीनों भी कल dismiss कर लेंगे.
So, Lord, this is not a accused, Lord, in a solitary case, but there are a number of cases against him which have been interfered.
That argument may be valid for rejection of bail, criminal antecedents. But if the evidence is same and on the same evidence, if he is facing 10 or 15 cases,
There was some scope, Lord, for.
ask your junior to give the number of those other 3 cases.
It is there in the office report.
बाकी क्या कल लगाए
In the office report, it is there.
पिंड से क्या मुझे?
They are along with this case, 35, 35.1 and 35.2.
There are 3.
3 cases.
All this.
All.
Lord, I am thinking of password.
My lord, this is the regular bill, lordship. Lordship, the petitioner is the driver, and the other quirks is on the bill, lordship, and his custody is more than the 1 year, 4 months.
Only 1 year, but then you are the driver, then it is.
Driver, lordship.
On the trunk and rear seat.
Lordship, and
Who is the person who is released on bail?
two Lordship. Lordship, and actually P5 page number 49, Bablu and Lekhra is on the bail, Lordship.
What is the role attributed?
I am the only the driver. And
So what is the role attributed to them?
the Bablu of and the Lekhra with regard to this?
Yes.
Well, the role is there, this is the owner of this car, Lordship, because at the time of recovery.
Was he in the vehicle, Bablu?
Bablu and Lal Chand is the owner of this car, Lordship.
Owner would be, you are found in the possession.
And my lord, my custody is more than the 1 year, 4 months, Lordship.
Any will issue notice. What can 4 weeks.
Much all right.
This is a very limited case, not even issuing a notice. Matlab, what has happened is, I am out on bail for matlab, after serving 17 months. Another co-accused who is still not on bail, your lordship had directed the trial to be expedited in his case. In February this year, the trial court judge wrote to your lordship said completed in 6 months. Proceedings are going on fast, I am participating. But the process of that, what's happening is my quashing petition, because I was.
But then you can make up that prayer in the quashing petition itself.
So I have made the prayer. What has happened is I moved an IA in the interim order. Now, for July, it's been listed. Plus, my trial is moving fast. I am participating. Effectively, my quashing will become infructuous. Earlier, they had given page 95. They had given a date of 5th May. I am only saying kindly request the High Court to dispose of expeditiously in May, June, because otherwise, what will remain of my quashing if the trial is finished?
Sorry, the learned counsel of the petitioner raised that though his quashing petition is pending before the High Court, the trial is proceeding further. He submitted that in the event the trial is completed before the quashing petition is decided, the quashing petition would become infructuous. We therefore request the High Court to take up the matter expeditiously and decide at least the question of grant of trim stay.
I am so grateful to the court, extremely grateful.
We are informed that the mediation is not succeeding. There are two matters here. One is a contempt, one is a clarification. Your lordship should issue notice on both during the period, although I have still been instructed beyond my reasonableness. I am still instructed that I can keep the door open for an oral settlement if they want. But they are being unreasonable, otherwise, why you should issue notice? Two things. Contempt only 2 pages. I've got 2 petitions for my lord. 2 pages only, 28 and 32. 15-20-year-old matter, they set up an obstructionist, a completely new entity born in 2023 to obstruct your lordship's order. Just see 2 pages of my contempt, which my notice should be issued. Page 28. Just 2 pages. Page 28 of my contempt. Yes. And then I'll tell you about the clarification. Just, does my lord, both my lords have this? Yes, violation of status quo order of 1311, forceful entry in the suit premises. The contemporary respondent, assistance of local goons, forcefully attempted to enter that portion of the property undisputedly in possession of the petitioner. Mark Wallace, I have a sale deed and a ready to construct of 24 acres. The church dispute is only 2 acres. Your lordship's order of 13th of November 2017, 8 years ago, is not able to be acted by me because of this obstructionist now. On 24 acres, I don't touch them. 2 acres away, let it be disputed. On 24, I can't do any construction, I can't do anything. Now, let's kindly read. Which a complaint was filed with the SHO. The contemners have even installed boards of the fake entity, Executive Board of Methodist Church in Southern Asia, over the suit property, admittedly belonging to the petitioners. The photographs are so and so, they are annexed by me at 470. Come to the next page. In pursuance of this, the henchmen are disturbing peaceful possession over the suit property. Despite, now this is very interesting. Look at the judicial orders I have, even before lordship's order. Come to page 29. I have an injunction in my favor by Belgavi Court. I have a police protection order of 2009. I have a second order of 2015, a third of 2016, and a status quo order by your lordships in November 2017. And lastly, on this page 32, which gives the obstruction of the trial proceedings by putting in an obstruction. This is why we notice the necessity that you tried settlement, they are giving them some, we offered them some land and some money, but they are making it impossible for the request. Now, the second point is this. The clarification says that your lordships passed 2017 order 1311 2017, which is a separate volume. on the understanding that things will be settled then. It's a status quo order generally. And we are in fact relying on the status quo. Now, whereas after 9 years, we are unable to touch 2000, we are able to touch 24 acres out of 26, which the Lordship may clarify need not be covered by Lordship's order. Lordship will not clarify.
Order.
See the order. They are using the same proposal for mediation came then. We pressed contempt earlier also. They came up with saying mediation. We went to mediation, it failed. So show the clarification application. In the clarification, that order, but in the contempt itself, Lordship will get the order at page 44. Page 44. Why should Lordship go elsewhere? Just turn to 44 of the same volume Lordship is holding. This was passed when I was not implemented. In this order, I was not implemented. I purchased it in 2015. I was not implemented. The original suit 1 filed by so-and-so at Belgaum, page 40. We feel in the interest of justice important that the petitioner be implemented in the said suit as defendant and be allowed to file a written statement with a period of 4 weeks. Evidence will thereafter be taken by the trial court and a serious endeavor made to deliver judgment period of 6 months from a date of receipt of a copy of the order from this court. Meanwhile, status quo as of today will operate between the parties. The sad effect of the status quo is 3 paras. Come to page 26 of my clarification. I am now teetering on the brink of bankruptcy because for 9 years I can't develop 24 acres out of 26.
Clarification there.
3 pages, page 26 first. Put it headwise. The petitioner during the operation of status quo has carried out several permanent alterations within the disputed area, regarding which no objection is being raised by R5 here. However, the petitioner opposed the efforts to bring about any change. The continued inability of this is me, para 2, to carry out development, which is indisputably in my possession, is causing, page 27, severe financial losses and distress. I have raised substantial amounts of money to invest and purchase the suit property from members of the Kulkarni family, which I have got 4 orders in my favor for. However, these funds have remained locked with no returns. The second ground is 27 bottle. No material development. The trial has been stalled completely. Look at that. It is pertinent to note that proceedings in suit have been completely disrupted along with this henchmen, due to which a conclusive judgment of filing is not foreseeable. In order to violate the status quo, in order to delay and delay, petitioner along with his henchmen has orchestrated a criminal conspiracy by creating a fake entity using forged, this is the obstructionist function, forged and falsified documents. This entity was created in 2020.
What is the contempt? What is the contempt?
Contempt is page 453, example directly. The sequence. What of the contents? Of the clarification, 453. They must filed a contempt and the clarification.
Clarification of 2017 order in 2025.
2022 file clarification, same now. They came and said the order records that don't clarify, we are settling. Same thing technically they tried now. And in the order of the Lordship dated 9/9/22, it is recorded, which is at page 453 of the clarification file. Page 453, clarification file.
453.
Yes. Every time it is there, they must delay it by saying settlement. Until they don't settle. Now, permission.
1 minute.
Page 454. The request of extension of time is granted. As the council states that in principle a settlement arrived at, parties will file terms of settlement before trial court. From 22 to 25, nothing is filed by them. In 25, I again go for mediation under a Lordship scrutiny.
You go for mediation because you volunteer to do so. We didn't compel you to do so.
The court, I'm saying what they do is whenever the matter comes for some relief in terms of construction, then your Lordship will not allow. The dispute relates to the church, 2 acres. 26 acres are involved. There is no issue on 24 acres. How can the order of 17 be read while settlement is not being arrived at permanently to mean a fetter on that?
But where is the contempt, especially as learned counsel for the parties, for the party state? Party, it doesn't say that this party, that party.
Without bona fide, I try. Verification.
Thank you, thank you.
Clarification.
No, sorry. We won't clarify 2017 order in 2025.
Because this whole thing is frozen. The whole matter is
There is a last order passed by Justice Dipakar Datta directly to be decided within a specified period.
or some other order now.
No, go before that. No, it is passed by the bench decided by Justice Dipakar Datta. Yes, they must.
Earlier order. They must matter before my lord. Anyway, now the entire matter, the SLP, I am told that.
On 19th of February 2024, Justice Dipakar Datta, sitting with Justice Sanjay Kumar, has passed an order having regard to the fact that several restrictions have been granted, yet the proceedings could not be concluded. We are also inclined to the view that not only extension as prayed ought to be granted, but a reasonable time should be given within which the suit.
I think this is some other case.
This SLP has been disposed of by your lordships.
This case, today's case is fully at large before my lord's bench. I know that for a fact, nothing else, no other bench.
No, there's nothing pending, my lord. The SLP has been disposed of. I'm very happy, but they made me a contemner. My lord, why I'm here is, they made me an alleged contemner after dropping me from the suit.
Order. The lordship said that parties will find terms of settlement. The next line is very important. The applications are dismissed and withdrawn at this stage in view of a settlement arriving. So we don't.
Where is the contempt to that?
My application for clarification is still there. The lordship may take that.
Sorry.
At that stage.
Thank you.
Then on the larger justice of it, let us forget these technicalities of contempt and clarification. I am beseeching my lord to consider on the larger justice. They have an order operating. They will not be interested in allowing the suit to go on or the 24 acres to be used.
Where is the suit is pending since?
2009 at Belgavi. 2009. This matter, I am instructed is entirely before my lord's only. As far as the main matter is concerned. Lord should fix any date, but after the vacation.
My learned friends'
Because my learned friends can't spot on the
are not accurate. There's nothing pending before your lordship. The third time, my lord, this statement is being made. There's nothing pending before your lord.
Well, let me do one thing then. Let me.
Better to withdraw it.
Well, may I say two things? I'm seeking instructions. Either, Malus, if they want to settle with us, we can come back in 2 weeks. It is a genuine desire. Not any mediation, just the two of us. Or, Malus, you ought to give a direction for the suit. And Malus, we'll withdraw these 12.
No, if you want to, you can explore the possibility that
They brought me from the suit as a party and they're filing contempt.
What is the stage of the suit? We are not inclined to entertain both the application, both the contempt petition as well as the clarification application. However, taken to consideration that the original suit number 1 of 2008 is pending before the learned Additional Civil Junior Division Belgaum for a period of 17 years, and that the status quo order is operating, we direct the learned trial judge to decide the suit within a period of 1 year from today. If necessary, the learned trial judge may proceed.
Let it be 6 months. Let it be 6 months.
It is made clear that no further extension would be granted in the matter. And if necessary.
In light of this, I withdraw these.
One would be, first let us The trial, this, it disturbs our flow when we are in the. And if necessary, for expeditious disposal of the trial, the trial court may proceed on day-to-day basis.
I'm very deeply honest.
Yes, now you can say what you want to say.
Only one withdraw these contempt and
Allow-
clarification,
allowed
not
to
much
withdraw.
meaning after.
Justice Durrani, my lords, the terms of settlement were out, almost arrived at under 50 crores. They said we'll take 50 crores, give us 4 acres. That was recorded, my lords, only the final thing has to be signed. And every time, my lords, once the final payment has, we were willing to pay 15 crores, that was recorded.
You are appealing for whom?
That's the same party, my lord, there are 2 applications. But the thing is, my lords, it appeared. Almost, my lords, the pen was on the paper, my lords, it fails at the last minute, every time.
And then when
Maybe at times the lawyers don't permit.
closure, they will never send. But anyway, your lordship is given a 6-month direction now.
1 year. 1 year without no further extension.
Earlier 2 orders of 6 months.
We are clarified that no further extensions.
I wish to withdraw the will of this petition as the petitioner has joined the dental college. Initially, she was selected notes in
Which matter?
Priyanshi.
Allowed to withdraw. Allowed to withdraw. Block करके रखा था वो.
Please. This matter was listed on 15th April months.
Is the client present in the court? Ask him where does he want to go?
We are lordships and
There must be some prison at Amravati also. Vijayawada.
there would be
There must be some prison at Vijayawada. And TR will give him a choice.
submitted my in your lordship's hands on this.
We'll give him a choice. Ask him where does he want to go. The officers should not feel that they are above law. He was warned by the court once, and in spite of that, he repeats it. We'll take him into custody right now. If somebody is playing with the dignity of the high courts, how do you justify his conduct?
As I submitted I cannot do this. We were only before your lordship.
No, but mercy on what ground? When on 11th of December 2013, he has been specifically warned. Does he feel that he is above the High Court? Does he feel that he is above the High Court?
There's no question. Can never be.
Ask him why he did not comply with the orders of the High Court.
Which I'm answering. Before your lordship.
Why you did not abide with the directions of the High Court? And how many families you have dishoused? Take 80 police along with you to disobey the directions of the High Court.
May just consider.
Consider a person who does not have regard for law.
Considering that what he has done is completely otherwise unpardonable. The lordship may consider maybe imposing heavy costs on him can probably be deposited for the benefit of the legal aid. Yes, Lordship may consider that alternative. That is all I'm saying.
No. He would lose the job if he is in custody for 48 hours.
Beyond 48 hours, he'll lose his job.
चिंता कर लेते एक आध those persons whose houses were demolished by him.
May I just submit something on that? That was the time when there was this agitation going on between Andhra Pradesh and Telangana. That year, Telangana had come. So it seems that during that period, because of this, government lands were being encroached. So there is no specific list. The contemners, in fact, the petitioners also who had gone. In subsequent inquiry, it was found they were not living there. Yet there were persons who had applied for government land. I believe around 67 were finally allotted. That is the reason, my lords, on civil side. Otherwise, there was no other writ petition which was filed seeking any other benefit, my lords. It was under those circumstances that he did something which was otherwise he should not have done, my lords.
What is this Guntur Town Mobile Laundry Union?
Because this is a union again of those people who claim that they are staying there. So this is one union, but again subsequently they never turned up. And considering
No, but who filed the contempt petition before the High Court?
So there were two of them, two lots. One lot was around 4 petitioners who had filed saying our huts have been demolished. Other was this union who said we are comprising of these members. So it was 2 contempt petitions which were filed at that point of time. But at least those individuals who had come, they were subsequently checked because of their application and they were found not to be living there at all at any point of time. They were not residents of that place. And so as the union are concerned, my lords, again the individual members never came forward. And whoever had come forward, they were granted the land and then they had been allotted the land in terms of the scheme of the government.
Oh, which were the slums which he demolished?
My lords, the submission before the Honorable High Court was, my lords, these were the ones which were being constantly built up overnight. In fact, the order in which the Honorable High Court had sternly told him not to repeat, that also order directs the petitioners at that point of time not to construct. But it seems that constantly those constructions were going on, overnight constructions, maybe temporary sheds or huts were being constructed, my lords. As I said, my lords, those were some turbulent times between those 2 states when the split was going on. And as Tehsildar, my lords, your lordship are aware that he was in some obligation also in terms of direction to clear out. He did what he did was wrong, but because of that, I think he was just in a situation where he was also required to follow these.
He was required to disobey the directions of the High Court.
So that is, as I said, my lords, that is something which is unpardonable. That is something which he truly understands, my lords. That should not have been done. So that's why I'm humbly submitting, my lords may consider, in some manner, lordship may just consider his job is still safe. He has 2 children who are minors.
No, he should have thought about them when he saw so many slum dwellers. Those persons also had children. What is he now?
My lords, he is deputy collector and on deputation as director of protocol.
Director of protocol. Director of protocol of
To the government.
State of Andhra Pradesh. He is duly qualified to be that. Whenever some VIPs come, we can just clear off the roads and by demolishing the houses. In ordinary circumstances, we would not have entertained the present SLP. So, in as much as the respondent, the petitioner had an audacity to disobey the directions of the High Court, dated 11th of December 2013. Paragraph. After taking a limit, we are inclined to issue the notice. The notice is made returnable on on 5th of May. On a lawyer, they would be provided a legal aid. Your only concern is to see to it that his children, they don't go on streets. Let him serve as a patwari in some village.
Considering what is done, my lords, I leave it to you. Whatever your lordship would say, we'll look into.
Serve them by Dusty Bombay.
Lordship will take that. I leave it.
I on board.
I leave it.
Also. Yes, Mr.
Well, these people have never been heard, so we had filed an application for recall.
Tag it along with that matter.
Very well. Well,
What we will direct
our application still pending. Meanwhile, all this is happening, Manoj. I have actually validly purchased it in an auction. I have sold it. Meanwhile, all this is happening. Manoj, this will completely frustrate my.
But proceedings are still still pending.
My applications are still pending. I'm telling the division bench, please first take up my application, hear it, dispose it off. The division bench says, no, we will not take up your application. We'll go ahead with the other matters. Because I am the auction purchaser.
Run the petitioner. Though the petitioner is auction purchaser, and though his implement application is pending, the High Court, without deciding the same, is proceeding further with the main matter. But we request the regional bench of the High Court first to decide the implement application of the petition and then to proceed with the main proceedings.
So those directions will be in abeyance till they decide my application. These directions have to be in abeyance.
But what are the directions?
Well, as that remove all these people as encroachers, treating them as encroachers.
He said application shall be decided within a period of 4 weeks from today. Until then, the order passed by the High Court shall be kept in abeyance.
I am obliged.
My lord, the lordships are hearing, my lord, SLP against the same impugned order tomorrow. My lords have tagged it with the main case where, my lord, the division bench of the High Court had taken a contrary view than the earlier division bench. My lord, the lordships are hearing it tomorrow at serial number 20. They are listed.
The High Court is, I think, has reported to a larger bench.
That's right, my lord. And the same reference order your lordships are testing tomorrow, my lord.
Tag it along with that.
Tag it along with that, my lord. What I'm seeking is interim relief only, my lord. I'm a woman inside for almost 9 months now, my lord. 10 months.
Tomorrow.
Please note.
Seeking a short pass over. It's for both item number 64 and item number 65.
But now we have already clarified the position. You can go before the Guwahati High Court and ask the High Court to decide in accordance with the. Same uske saath.
The condition granted bail scheme was for a period of 6 months on the health ground.
No, this 65.
Sorry, the court must have called out fact.
Go inside and then when your transplanting schedule, we will grant you bill that time.
I have to get ready for the transplant. I have now identified an owner under the relevant regulation in the state of West Bengal. She is affirmed an affidavit before the chief judicial magistrate. He is willing to give the organ to me. Now, the process is that I have to be treated in the same hospital where I have to undergo transplant. They have now moved an application saying, now you come to Madhya Pradesh. If I go to Madhya Pradesh, I am now down the donor list. Down the recipient list. I have to wait for another 2.5 3 months.
So when is your transplant schedule?
Yes, 6 months time. That's the last opportunity in Kolkata. I am not out of
not on the, I'm not on the merits of the matter. 400 witnesses, 12 witnesses have been examined. That apart, they do, for them to come and say that I must go from one state to the other.
No, you give us the schedule of your.
137. They say 6 months time is what the doctor says. It's 4 to 5 months time. We have identified owner. The donor has already affirmed an affidavit before the relevant judicial.
When did you identify the donor?
The affidavit comes to be filed only now. Affidavit comes to be filed because the failure took place in January 25. 27th January 2025.
Give us your schedule when it is when the transplant is scheduled. Then we'll consider.
Ask for 6 months from today. Because the point is this.
Now the transplant itself is scheduled after 5 months.
Because I have to get treated before that. Now the affidavit travels to the verification committee. The process, two things happen inside.
What treatment you are required to get before transplant?
Because I am undergoing dialysis 3 times a week. In the hospital, in the jail authorities, they couldn't give me dialysis properly even twice a week. Therefore, they threw their hands up. Well, on the last occasion, your lordship asked the AIMS Bhopal whether you can do the transplant. They threw their arms up saying we can't do it in Madhya Pradesh. Today, the victims can't say, because I go back to, I'm only saying as a last opportunity, give Bilal 6 months time.
Just tell us what is your schedule. You get the doctor's certificate on what date it is scheduled.
The instructions it takes 6 months. The doctor has asked for 4 to 5 months. I am saying 6 months because your lordship will.
It doesn't take 6 months. It doesn't take 6 months.
My lords, may I kindly submit something?
1 minute.
There are two problems here. One, from the affidavit given before the judicial magistrate goes before the verification committee, then the authorization committee once the donors are affirmed. The affidavit is now being filed before the CJM. From there, these two processes have to take place. After that, then the medical examination once again takes place because to see that at the last moment the donor does not have hepatitis, sugar, etc., which is the reason it failed in January. 27 January it fails.
That is just before the procedure.
Procedure starts. That's right. That's right.
So when is the procedure proposed to be started? To give us those. We don't want any vague things.
It's a process.
My lords, may I
One minute. I know you have a lot of things to say.
My lords, may I be please allowed to come in?
Yes.
My lords, the first thing to be noted that my learned counsel is not bringing before your attention is that the first time Rajesh Agrawal, the main accused in the Harda Blast case, had secured a donor was on 29th January 2024. This was a record part of their original SLP that they had filed. So, my lord, even before the blast took place on 6th of February, 29th January 2024, he had secured a donor from West Bengal. Now, after the blast took place, he applied on that basis for an interim. Now, 29th January till today, my lord, about 13 to 14 months, has any request been made by the donors or by the accused either to the verification committee or to the authorization committee? My lord, first of all, the donor very well belongs to Madhya Pradesh. The first time in January 2024, they had gone all the way to West Bengal to find a donor there. Now the affidavit that they have put on place 2 days before this matter was listed, my lord, is a donor from Bihar. And my lord, they are proposing that they want to get the transplant done in West Bengal. The state has put on record.
There are certain difficulties because that is permissible only in West Bengal.
My lords, so
the regulations differ from state to state.
that is right, my lord. Very, very well, my lord. But the transplant.
Get the date. Otherwise, we will not.
But my lord, now the state has put on record that AIMS Bhopal is stating that now they have the facility, they can carry out kidney transplant. That is only one factor, my lord.
Madam, there are certain, every state specific regulations. There is some reason why he is going to West Bengal.
That's right, my lord. But even as per West Bengal, my lord, even as per West Bengal.
When will you give us?
My lord, but may I just bring on record another thing? My lord, 6 months was given to them for interim bail. But my lord, I have placed on record several documents to say that within these 6 months, look at his conduct. There are media reports to say that it's.
Monday.
Yes. Notes, this is the class 3 healthcare worker. Notes, we are 11 before the launch. Notes, the impugned order has set aside the single judge order. Notes, where I was reinstated.
Notice, जो connected matter में order किया हुआ
e-filing delay may kindly.
No. It's okay.
My lords, the state of UP is before your lordships, my lords. State of UP is before your lordships.
Yeah,
my
but you
lords.
already complied with it.
No, my lords, we haven't, my lords. This is counting of ad hoc and part-time services for the purpose of pensionary benefits. And in fact, my lords have protected us, the same officer in the similar matter of other doctors. We seem to be coming here often for these contempt. Very grateful.
Item 15, I am seeking 1 week accommodation lordship because my father is hospitalized. So I could not prepare because I got a one judgment in my favor, lordship. Justice Oak has passed in 2023. Because he wrongly this thing.
Okay. You don't disclose that you are facing criminal proceedings where you file an application
That was online, lordship, because he has chosen.
online, but then was there a column or not? When there are any criminal proceedings which are filed against you, if you say no, in spite of criminal proceedings pending, you might have been acquitted. It's a different matter. But suppression of itself is a serious thing.
But immediately after appointment, he has.
You appear to be ready.
But for my satisfaction, 1 week required. I got one judgment in his favor.
Okay, if you want disposal, postpone.
Applies.
Call out twice. None appears. In any case, the reliefs as sought in the petition are exclusively within the domain of within the policy domain, either of the executive or the legislature. That view of the matter, we are not inclined to entertain the petition.
My lords, this is the matter whereby the High Court has quashed the FIR against the accused person. My lords, from the statement, High Court has only said.
Your 161 statement says what was the fact, and then subsequently you improve your story.
My lords, the reason has been given in my supplementary affidavit because my father and the relatives were there. Therefore, I could not elaborate. But my story is also corroborated by the witnesses' statements, my lords, which is there at page 94. My story is that he actually, my lords, may have page 94.
Very unbelievable, madam.
My lords, the complainant has specifically stated in the statement that when the parents used to go to sleep, thereafter she used to call the accused initially. And in 2024, the accused said that I don't want to marry you. So initially the relation was consensual, but subsequently it was not. And on the pretext of marriage, he used to force up a physical relationship. If my lords may allow me, I can place reliance upon 2024 judgment, my lords, wherein this honorable court has said that the relation can be consensual at earlier stages, but subsequently it can be non-consensual, my lords. My lords, if I may hand over.
Yes, you can hand it over.
Of the complainant is supported by the statement of the answer. My lords may have page 94. That they, my lords may see at para 4 of this judgment. Para 4, my lords, 6th line. A relationship may be consensual at the beginning, but the same.
There, in this case, the High Court had declined caution.
Yes, my lords. My lords,
And the High Court, this court concurred with it.
my lords, in the present case, if my lords may see the observation of the Honorable bottom, my lord. My lord. My lords, my seat para 11.
Do you know any lawyer from Aurangabad?
No, my lord.
You don't know?
I don't know. I know from Nagpur bench, my lords, I know.
Or you can ask Mr. Shehjazi. Just show him page number 1. Fourth line from bottom, Mr. Naidu.
Yes, please.
Don't read.
I will.
Read it to yourself.
Yes, please.
Can it be interfered? Dismissed.
My lords, delay may be confirmed.
And delay control.
Mail please, minutes. Minutes, voice sampling minutes. Extortion in the name of an accident, death in the family minutes. Grateful.
I accept notice, my lord, on behalf of the.
Yes, there is a judgment by this court. Yes. There is a judgment reported in 2019 8 SCC page 1. And when there is a Supreme Court judgment, how can the High Court say that since the matter is referred to a larger bench?
And that's become infractuous.
Okay.
Sure.
This one so well notice.
So of all this, I can only say that the main thing, but that there was a death in the family. The girl, she died. But that is nothing happening regarding that. It has turned the U-turn.
My lords dealt with that matter earlier.
I put it on affidavit. I put it.
We are only concerned with the legality of the order.
4 weeks now. Great.
But verify the present status. Now, I think next year's process is already must have commenced. Next year's process must have commenced.
And over a chart of the government seats are lying vacant. And in order the
Oh, till when it will go on?
They have fixed the schedule, first of May, not just the balloon. This is for the government seats. In Malad,
Government seats for 23-24 academic year.
So Lordship will just have a look at that. Malad. This is a schedule for PD seats in Malad, Government Medical College, Chandigarh, which is Malad, the UP. It is virtually managed by the government itself, DGHS. And the schedule, Malad, goes up to 5th of May, starts from 22nd of April because they have vacancy.
Yes, so take instruction on this if you can.
Ultimately, it is conducted by NMC. Let NMC be implemented. We have got only instruction about it.
NMC doesn't conduct the counseling.
NMC, that is fine.
Very well. Counseling it is conducted
But
by
nevertheless,
and we would request, Malad, is the same schedule, 59 seats, Malad.
There has to be some sanctity to the.
No, I have bowed down, Malad, but what I'm saying is that the DGHS is the
Who is applying for the Union Territory?
Union Territory, we take.
Because the counseling or lordships are aware that
The schedule is fixed by your college.
Chhattisgarh.
The Chandigarh.
if your lordships will not show indulgence, same schedule can be fixed for us. No, I am not. It's not Chhattisgarh. It is Government Medical College, Chandigarh.
This is from Chhattisgarh. You are calling from Chhattisgarh.
As far as Chhattisgarh is concerned, minutes, I represent. Our college has only 2 seats vacant, minutes. And minutes, my lords may kindly appreciate minutes. When it comes to regular students, we charge 10 lakh rupees and we pay back every month 70,000 rupees and we get nothing. We survive on NRI. Millets NRI, they come on the last date, they negotiate. Otherwise, we cannot fill the seats. So that's how they twist our arms. That's how 2 people left. Based on wrong information they have furnished Millets, we could not admit that. Now Millets, unless we have had it Millets,
You are
no way we
from
could
Chandigarh.
survive.
application.
Your college is from Chandigarh.
My college is are in West Bengal, eight colleges in West Bengal. We are showing your lordship the effect.
Thank you, dismiss.
The government is sort of continuing to not be that.
Thank you.
Millets, one chance, millets, only 2 seats, millets.
No, thank you. To open a Pandora's box.
We are only requesting same schedule, what the government.
You already dismissed, Mr. Singh. We don't permit post-order arguments.
This is the subject.
That is privilege of only Supreme Court lawyers.
It's not our privilege.
No. And fortunately, unfortunately, both of us from not Supreme Court. Yes.
Your lordship are Supreme Court.
We are not from the Supreme Court. We come from High Court. Yes. Thank you. Now you just go and show our orders to the High Court. That's all.
Can I just tender a chart? 6 states, my lords, after the clarification order, my lords have issued notice in the transfer petition. For Odisha, it was 2 days back. On Friday, my lords, they issued notice. The state there is taking a stand that the original judgment has not been recalled. So therefore, they are taking the defense.
How?
That is one. And therefore, my lords, this chart I prepared the 8 matters.
We are not in the transfer petition.
Kindly hear me. My lords, just 1 minute, my lords, may give.
The petitioners can very well.
May just give me 1 minute. There are 8 matters already pending where notice is issued by my lords after the clarification. All that is another state. My lord, may kindly.
We will dismiss all of them together.
Just kindly bear with me for 1
We will dismiss all of them together. We are saying we are asking it to be listed. Give them the list of those 8 matters.
I will give. If the list is required, I'll tender.
Next week.
This will also be listed with that.
Yes, उसके साथ tag along with one.
In fact, one of them was allowed by my lords by the speaking judgment, my lord. What is happening?
Therefore, we are saying that now with our clarifications, all doubts should be traced.
Suggestion, my lords will list all of them and decide them by a common order. We'll be more than happy.
We will say that.
Very well, my lords. 8 cases.
This common order that we have clarified it by 2 orders. Now let the petition go back to the High Court and we decided on its own merit.
9 cases will be decided on that day.
That is why we are requesting.
Indeed, my lord.
You give the list.
Yes, I'll be fair to the cause. Both the 64 and 65 may be listed along with that. Any date, my lord.
Next Monday.
Very well. Grateful, my lord.
I have got the respondent. Is this temple?
We have granted stay after hearing the review of the order.
No, not only that, your lordship knows that pension was introduced in 95.
Yes. And we have directed that your regular pension shall be paid regularly.
We have also taken out an application. He is not a pension optee, he is a PF optee. So, my lord, that was an option given at the time of introduction of pension in public sector banks. So, my lord, that part of the order, my lord, we have also taken out an application, my lord, that's also listed. So, my lord, that's IA number 165297.
No, but that is not listed.
That's not.
That is not.
Only one IA.
That if you take up all, my lord, my suggestion would be your lordship may hear your lordship already ordered expedited hearing. So, let the matter be listed for hearing.
The application to be considered along with the main petition.
My lord, they are not communicated. After order passed by the honorable court, they are entitled to get this pension or not. They are not communicated any letter to the incumbent.
Thank you.
Sir, let it be fixed in a particular day.
They will give the date, yes.
I have that.
Well, it is a matter of preventive detention and without following that due process of law, I have been detained since 11 months. Well, they have not complied the most important characteristics of the preventive detention that is derived from the Article 22 and that is the right to representation.
Particularly we heard fine.
Granted leave in this matter today to IAS for early hearing existed.
And
I have it any day.
Early hearing granted. अगले महीने में एक दिन रख दो.
My lord, the period gets over by 13th of May.
So most of the habeas corpus meeting that is the fate.
But my lord, that is the urgent because they have not followed any procedure in these matters. And I've been detained since 11 months.
Yes, sir.
But the pleadings and complaint in this matter, except for UP Chandigarh, has not filed a reply. Now, my lords, what has happened in this matter, if I can just place it before you, my lord. The petitioner before my lords, gets a green technology cement into the country. My lord, he then has an agreement with the complainant, my lords, who is now party to these proceedings. The complainant gives him about 80 lakh rupees draft, my lords. Now, to take that technology from him, he and his family is involved in multifarious FIRs, 3 FIRs based upon the same 80 lakh draft, saying that 80 lakh draft was given to somebody so that he can travel abroad. Another FIR is registered. Then the mother is involved in another FIR. The brother is involved in the another FIR. Mallards. They take a transit bail for him in Mumbai. Before that, Mallards, 2 days, he is kept in torture, wanting to get some documents signed from him. He is brought to Chandigarh. The concerned officer, Mallards, extorts 50 lakhs from him, takes away the family jewelry. That very day, he files an FIR that I have run away from custody. Then, Mallards, I approached the Honorable High Court.
Who is appealing for the state?
They filed a reply. And very interestingly, now in the reply, they say that, look here, we are looking into everything, or something very important happened. On 18th of February, the High Court appoints an SIT that look into who had registered this FIR and taken money from these people. Very interestingly, without informing the High Court, they changed the constitution of the SIT. Then the SIT goes into the FSL. His allegation is that I have not signed the agreement because I say that 80 lakh draft you can't use to register 4 FIRs against me. The SIT and the FSL report say that the signatures match. He is the signatory to the agreement. But the moment that report comes, the SHO on his own supersedes the SIT, moves an application before the magistrate for a second opinion. In the meantime, what they do is, I am a complainant in one scam called the syndicate scam. I am a complainant, pointing out in Rajasthan that there are bank officials entering into fictitious loans because I was operating from there. But I am not named in the predicate offense CBI at all. But after 10 months, they get me named in the ED matter and put me into custody for 14 months. I am the complainant in the predicate offense. So when I say this is senior officers are involved in this matter, this is an issue where one instance has been used 4 times to register an FIR against me, victimize my family, superseding the orders passed by the High Court for appointment of an SIT. And once the forensic reports comes in my favor, the SHO on his own supersedes the SIT and moves the application before the magistrate. Since jurisdiction of 3 states are involved, then what they do, in one of the matter, when your lordship grants me protection, they register an FIR against me in Haryana. Now the Haryana government, the state of Haryana has filed a reply before your lordship to say that we found that FIR to be bogus, we have cancelled it. One of the FIR registered in Punjab, now the SIT before your lordship says that we found it to be bogus, we have cancelled it. And they say that this complainant who's registering the FIR, we've called him on 7 occasions, he never appears. Now against this complainant, what is the allegation they make against me? That I have sent Mr. So-and-so abroad using 80 lakh rupees. That is the same 80 lakhs which he has given me as a draft for signing the agreement. I have nothing to do with immigration, visa, nothing at all. The moment I try to satisfy them that this term sheet is rightly signed, another FIR by a third person that I am involved in sending some people to Hungary for immigration. I got nothing to do with immigration. That 80 lakh draft is again used. So I say, this is a matter where senior officials are involved. Despite the fact that the High Court on 18th of February 2022, just kindly see the order, my lords, passed by the Honorable High Court. Just kindly have, my lords, volume 2.
But why can't you seek this relief before the High Court?
Not because there are jurisdiction of 3 states involved. There is Rajasthan which is involved. I was kidnapped in Mumbai by these police.
Yes, but then you can go to any of the High Court where a part of cause of action arises. It's a settled law now.
What has happened here is this. What has happened here is this.
The Lord may see the relief.
Just
none of those reliefs can be granted the way it is being asked. that I should not be investigated upon.
No, I do not say that.
No
I say
FIR should be
give it to
registered.
an independent
Give
agency.
notice to me.
And what
Yes,
is
about the entire investigation process.
You are appearing for whom?
How is the complainant? He should be happy.
So Aryan, you are appearing for whom?
I am appearing for R12. R12, my lord, respondent number 12.
Who is he?
The person with whom he had transacted, he had taken 1.22 crores to send 200 students on a visa to Hungary.
There is
And
no,
he exported them.
there is no R12.
No, that is the same draft he uses.
And
This is the term sheet.
interestingly, he
And
forges
he-
my signatures on an agreement. The CFSL has returned a finding saying that my signatures are forged.
No, that's wrong. CFSL has returned
This is-
finding that Finland's signatures are right.
The-
And that is why the superseded.
We got 8 FIRs in
No, no,
which
no, just kindly have just one
the
thing.
man pleads innocence. There
Just
are 8
kindly-
FIRs against him.
The present petition has.
He changes his name in the basket.
One minute. Seeking a direction to transfer the investigation of the FIR mentioned in petition to the Central Bureau of Investigation. To a pertinent query as to why the petitioner has not approached the High Court, who is competent to grant such a relief. From the Shivali, the learned senior counsel for the petitioner, states that since the petition involved the jurisdiction of 3 high courts, it is only the Supreme Court which can enter in the present petition. Paragraph. The law is very settled, where a cause of action arises within the jurisdiction of more than 1 high court. The party can approach any of the high courts where a part of cause of action arises. They are therefore not inclined to enter in the present petition.
Can I make one request to your
Directly, Supreme Court.
Sorry, can I make one request to your Lordship? 13th of November, Maharashtra granted me and my family protection. Maharashtra continue that for 10 days, I will not be able to.
The interim protection which was granted by
The High Court has granted protection in 6 matters.
No, that is not there. That is incorrect. That is incorrect.
The interim
I do
protection
not for the other right.
the interim protection which was granted by this court wide order it is granted to the petitioner and his family.
Please.
Shall continue to operate for a period of 15 days so as to enable the petitioner to approach the
I'm grateful.
jurisdictional high court.
I'm so
In
grateful.
fact, Manoj, clear me that at least the problem is that when we add Maharashtra, we add Rajasthan.
So therefore we have said that
Yes, yes.
how did
To any one of those courts, continue.
Article 226 is very clear on that.
Yes, yes, Article.
You approach any one of them, you will be there on even grounds.
Grateful. Deeply obliged.
I'm so grateful.
Lord, I appear for Chandigarh administration.
Yes, Mr.
Served just 2 days back, my lord. I'll have to put in my reply.
2 weeks.
Please allow.
Lord, may I keep the list of dates on record?
No, we give it with you, give it to us on the next date.
I'm seeking to pass over in 45 minutes.
Have you also had some anybody? NMD?
Then your lordship kindly consider having it in the, because it was in the NMD, it is earlier, just recently, somehow it did not reach, etc. So if your lordship could have it, so if your lordship could have it on a shorter date, that's all. Next week.
2 हफ्ते के बाद
Well,
2 weeks.
2 weeks.
My lords, the demarcation report has not been given to us. Lordships, we approached the authority, they refused, saying that it is confidential. That may be provided.
We may be given it.
तो आया कि डिमार्केट रिपोर्ट से देखो
I believe it's not called for, but it's been sent in a sealed copy.
whether the salary is executed in your favor.
September 2022, my last election, 3 months' time. So far, it has not happened.
Demarcation report was not available. Lordships may direct the registry to supply a copy.
I, correct. The learned counsel of the party stated that as directed by this court, the demarcation has been done by the additional director of land report, Bangalore East. We direct the additional registrar of Bangalore East to hand over the demarcation report to the party petitioner as well as the response number 2 and 3. So that further steps can be taken by the party. The demarcation report is furnished within a period of 1 week, within a period of 2 weeks from today. On receipt of the said report, the response number 2 and 3 shall execute filled in favor of the petition within a period of 8 weeks thereafter. Could have after 12 weeks.
Lordship, may I request after handing over of the demarcation report, the Lordships may have the matter after 2 weeks?
No, we already directed that the SILD has to be executed. The difficulty is that both the sides go on changing their lawyers, so they don't know what happens on the earlier date.
My last, can we grant us a date minute so that we could come back to your Lordship's any grievances?
Opening के बाद दे देना चाहिए.
Great.
My lords, MCD is before your Lordships, my lords, denying us, my lords, the working plan condition. Same plot on the same road, they have allowed another plot, but they have not allowed to us. My lord.
Please, Lord, I pray for the party.
For Lordships, our humble request in this matter, Lordships, the entire dispute will be resolved, Lordships, if only the PWD and DDA are also called, Lordships. They will ensure, Lordships, whether at all this land is required by PWD. Right now, for past 30 years, they have not used this
But if
land.
they are owner of it, how can you refuse a sanction to them?
Lordships, only because the land use is transportation today. DDA has in fact changed the land use for remaining of the road to residential. Lordships, DDA can again state that this part of the land is also back to residential. So, Lordships, if my humble request, Lordships, we have moved an application for implement. Let DDA come forward, Lordships. We are an implementing agency. If the land use will be shown as residential, Lordships, we have no difficulty with that sanction, Lordships. We are bound by the master plan, the zonal plan that shows this particular property as transportation. However, we also have inquired, Lordships, much part of the same road has now been changed to residential.
Dismissed.
Lordships, if I may humbly submit, Lordships.
Thank you.
Lordships, it is a road around the Lordships, a crossing where the land has been turned into.
You cannot deny a owner of a property a permission to construct a building. If you want, you acquire it.
Yes, Lordships, so the acquisition has to be, Lordships, if we are only the municipal corporation of Delhi, Lordships.
You are the planning authority.
Lordships,
So your only lookout should be as to whether the plan is in accordance with your bylaws
Yes,
or not.
Yes, Lordships. So therefore, Lordships, as implementing agency,
Next matter.
Lordships, our humble request, Lordships, if at all, the planning body may be called, Lordships.
Dispense with cost quantified.
Lordships, I'm sorry, Lordships. It is, I was only trying to make it.
10 lakhs.
Lordships. That was our humble request, Lordships.
20 lakhs.
Lordships.
As soon as you leave, we will treat that.
I think it's short path over. Led by Mr. Narendra, based on his legs. But the connected matters have not been listed.
No, this is child custody, will not be mentioned, it got it listed.
But the other three matters which were listed last time have not been listed.
That's fine, we're not.
The Bangalore matter.
Bangalore matter, we have not seen the child for a year.
Well,
We have
for good
succeeded till the Supreme Court of India. Now, my lord, once the High Court,
July में रहते हैं ना?
Your Lordship, I have it.
July.
No, what happens is this, my lord, the child is not going to the school for last 1 year. The child has not.
We are aware about it.
Very well.
My land is taken by the electricity board of the state without any compensation. But when a writ petition is filed, I must point out the original writ petitioner was father of the present petitioner because he died in the meantime. When the writ petition was filed, relief was direct them pay compensation. Their stand was that possession is not taken over by us. On the basis of that, oral submission was made. An order was passed for appointment of commissioner. Please have a look at the order at page 53.
On what basis say that your land has been acquired?
They say that we have not taken possession at all. So my brother's lands are taken on the basis of a registered gift deed. My land is not taken. That is their stand. And
We will have it on some NMD. NMD.
the worship may grant specific.
They will grant you the right.
Clear, please. So this is further covered by the Lordship series of order whereby Lordship at page 9900 Lordship have been time and again have been saying that the enhanced compensation 50% of the amount will be with security and 50% without security. That is what your Lordship is asking.
Yes.
My lord, I appear for the respondent number 2 as JMITC, my lords. They have not made an application before the High Court. In fact, my lord, the High Court had only issued notice and that too in delay also, my lord. They have just issued notice and the question of delay is kept open.
Because High Court says only
make an
70%
appropriate
of the
application before the High Court, my lords. For withdrawal of the amount, my lord, 70% High Court directed us, my lords, we deposited it within the time, my lords of bill.
So that is what I'm saying. Your Lordship has been time and again.
So where is the order with regard to 100% deposit?
Yes, on page 99, just have a look, page 99. Series of orders are there. I'm just with the last order which is there on the record, Lordship, page 99 and 100. Whereby in that case of 50% which was permitted by the High Court, Lordship relying on the Wajirmia judgment, Lordship paragraph. And we have several orders on this issue. Reference that we made to one of the single. It is not to the similar matter being such and such. The High Court order saying the permit enhanced compensation has been modified to the effect of 50% of the enhanced compensation being engaged without your security and balance 50% to be furnished with security. That is what I am asking for. And Lordship.
But there is no order with regard to. Have you made an application before the High Court for withdrawal? To the Supreme Court for anything.
Just have a look, page 169. This was brought to the notice of the High Court. Just have a look, page 169.
My lords, in fact, the
Just have a look.
judgment of reference court.
Just have a look, page 169. This was from the same notification, page 169 by the High Court itself. At page 170, High Court direct to deposit 100%, whereby in my case says only 70%. That's all difficulty. Just have a look, page 170.
Next part.
Document granted that working for me to.
Yes. If you don't want that, we will withdraw it. If you don't want that liberty, we will.
Lord, this is the matter, my lord, which we have come against the order of the Bar Council of India, where the Bar Council of India has rejected my revision request. My lord, there are 4 serious allegations of fabrication of bills, my lord, fabrication of member of this honorable court, my lord, making statement without instructions and not filing a proper rejoinder. My lord, may I kindly see, my lord, 2-3 documents just to see the seriousness of the matter, my lord. The first was.
Can't it be settled?
My lord, I have spoken.
So can it be settled?
But I must tell your lordship one thing. I have myself not looked into it. I am satisfied, but I am not arguing. Sir. Lord,
So we issued notice because of the letter issued by one of the senior councils.
but that has nothing to do. There is nobody knows who is saying that. There is no
So
proof.
it is signed by the,
No. Yeah, just see that document. It's worth seeing. Please turn to that document.
you see 100, page 102,
Yes. Please turn to page, that document, at page,
102.
just. a second. Take volume, my rejoinder affidavit of petitioner. Kindly take that. Please see this page. Your lordship may kindly turn to page 89 onwards.
My lord, if my lord will allow, let me make the 4 points, then my lord can.
I will hear it at.
Because they are serious.
Kindly don't do that. Kindly hear, because it is a blot on somebody. If it's
Will-
your lordship may not admit it, but if he is not, I will show to your lordship what has happened here. I will show to your lordship what has happened. Just see 2 documents. Just see 2 documents. It is troublesome. But it goes in the whole career of a lawyer. There is really nothing.
So let me make up
The
my.
excess amount has been paid back to him. He has accepted without a demur. The excess amount has been paid back to him. He accepted it without a demur. This document of Mr. Sibal, he files after revision is dismissed by. He procures after revision is dismissed by the Bar Council of India. He never produced it before Bar Council of Gujarat. He never produced before Bar Council of Delhi. Bar Council of India. It comes not admittedly after revision is dismissed. And I am not, Mr. Sibal's letter is correct. Nobody is questioning that. Question is, have I sent that memo to him? That note is doubtful. Please see, that doubt will be immediately clear. 2 pages and your lordship will see that doubt.
Lord, let me make my case first. my lord.
Yes, 1 minute, we'll hear you.
Just turn to, just see list of date, Lord. He admits that this document, this letter from Mr. Sibal was obtained after the revision. It's filed with an application of additional document with seeking permission to place on record. Now just see on page to my rejoinder, page 89. Every document has been sent which shows my photograph. Page 89, rejoinder.
So rejoinder is by the petitioner.
Yes.
Yes. Just see, no, mine. This, his rejoinder. Petitioner's rejoinder. Page 89. But the matter was admitted in 2014. Kindly, it's pending. The SLP is pending. Now please see page 89. The picture of the advocate on record appears. Then kindly turn to page 94. His picture appears. Then
No, this email is by what? By whom?
sorry.
This 89,
WhatsApp.
by whom to whom?
By the petitioner and respondent, the communication between.
These are communications between them.
And my lord, petitioner has the record of an original phones with him, my lord. My lord, may kindly see the contents of 89 and 90.
Now see, Lord, this so-called bill at page 107, 97.
Take 1 minute.
Page 97. Please compare it with page 89. It's not a document which is sent by him purportedly. His picture doesn't appear. And the fact is, Mr. Sibal has appeared on 12th of July 2014. 12th September 2014. Mr. Sibal did appear. What record shows that? Now, whatever may have happened, Lord,
89 you want to compare with what?
With 97. It should be put an end to. I understand Lord his feelings. He feels that maybe we should have got a stay order. But Lord, your court found that other side had already taken possession and started construction. It's not subject to lease pendants, page 97. His photo doesn't appear.
And for this document, which if he added, why is it that not he goes for proof only after the revision is dismissed? Naturally, not Mr. Sibal's office issues large number of memos, right? He says that we have not issued this. But not Mr. Sibal appeared, whatever excess amount was not paid by him has been returned to him. He has accepted that amount fully without any grievance.
Well, what is the material to show that the excess amount is paid to him?
That's an admitted position. That's an
Given
admitted.
by a check, you know, it's a part of a record here.
He has admitted.
But there are serious allegations, regarding manufacturing of bill, manufacturing of fabricating the memo of this honorable court. Only 2 minutes, I'll not take much.
Fabricating memo of this court?
This court, Milord, may I start with the memo, Milord. May kindly see page 49 and 99 on one side, Milord, of the writ petition. 49. Milord, 99 is the original memo, Milord. It's a certified copy which we procure from the registry, Milord. The petitioner procure. First, Milord, may see 99, Milord. And now, Milord, may kindly compare with 49, Milord. The court fee filed was 120, Milord, and it was charged at 11,120. And I'll show from the rejoinder, Milord. This is when we asked from him, they sent the photocopy through WhatsApp, Milord, and that picture is also there with the rejoinder, Milord. At page 97, Milord, of the rejoinder. This is the record of the filing memo. And Milord, may kindly see 94 of the rejoinder, Milord. Because the allegation in the rejoinder is that we have not filed the proof how was sent to us, Milord. So that's why the petitioner has annexed the WhatsApp communication, Milord. 94 of the rejoinder said purposes.
This always brings groups.
My lord, 56.
Why?
Pharmacy council.
No, why don't you bring some restrictions? Because though we have upheld the Delhi High Court, valid reasons and by regulations, we have only said that it could not be done by administrative instruction. Stop this mushroom growth, otherwise we don't know what quality of pharmacists we will have.
My lord, 56.6 is a different case, my lord. It is, my application is in time. They admit that they, due to oversight, they could not check that.
I know Mr. Sherawat must have built some pharmacy factory also.
He must be having a controlling share in one of the major pharmacies.
Yes.
56.6 is a different.
Yes, that you have already directed to it.
28 April.
Yes.
Sincere apologies, Malats. The money has to be paid to the petitioner, Malats. We are making the payment. Companies in the NCLT, Malats, still we are assured them to make a payment, Malats. Kindly have it.
4 weeks
Malats, kindly have it after. Malats, 45 days we are settling it entire up.
after vacation.
I'm grateful.
Yes, minutes. Thank you, University of Minutes. I believe minutes nothing survives in this matter as far as the respondent is concerned.
Just come to page 3 of the improved notification. I'm only requesting page 7 to be, para 7 to be sustained. That's the only request what I'm making.
Para 7?
Para 7 to be sustained. Page 3, para 7. Because there's a contention that the lady has made a misrepresentation. If that is the issue, then she will be debarred from applying again for any of the further examinations. High Court specifically says that there is no misrepresentation.
We will not come in the way minutes. Well, ultimately make it the order of the court for students' future.
What do you want?
For only this observation to be sustained, no, that's all, because the
He says that it has become infructuous now. We are dismissing it. So once we dismiss it as infructuous, where is the question of the observation being dismissed?
Minutes, nothing survives. Dismissal means everything gets revived. I say minutes, nothing survives.
In view of subsequent development, nothing survives in the petition, dispose of as such.
Great.
This is already decided by earlier passing the order, my lord. That was a separate attack pointed out on state. Because that was the fact that some students had changed their lordship could not go into the wisdom of the IITs. But the reason your lordship is protocol, I had argued. The number of attempts is in their domain, your lordship will not enter. That's more difficult to make. But here is a case where 3 attempts being given. And for the advanced exam priority, it's the main exam, only 2 attempts. So the situation is, today now the results have come from the main. Out of the 8 of them, I have the principal of that. 8 of them are within the 250,000 for that entrance exam. That your lordship noted and rejected, not accepted. 263. Page 263, only a minute. Completed, that doesn't apply, I'll tell you. Yes, the solicitor completed. Para 5. That doesn't apply, I'll tell you. Yes, the solicitor completed. Para 5. Page 263, my lord, your lordship was under challenge. Here, my lord, the attempts from 3 was restricted to 2. And your lordships were pleased to say this, my lord, para 5 and 6. 5, 6 and 8. It is submitted that due to the enlarged period, 5. Learned so-and-so submits that the decision notified in the press release dated 18/11/24 was taken in the larger interest of students. It is submitted that due to the enlarged period of consideration, the students could not concentrate on their studies and only spend their time in preparing for JEE Advanced. Be that as it may, we are not considering for JEE Advanced. Be that as it may, we are not considering the wisdom of respondent number 2 in restricting the zone of consideration either for 2 years or for 3 years. Now, please see, my lord, the prayer. Prayer is at page 35.
The very same press release dated 18/11/24 is under challenge. Kindly read para 9 of the order. Only, I'll read para. I'll read para 9. In the peculiar facts and circumstances, and without observing anything on merits. Correct. But after observing anything on. Plus, observing. And what was canvassed before the court was, listen, I have changed my position between 5th November when the notification came out and when it was nullified 11 days later. I am not on that.
Now, what is your grievance here for advance?
Yes, my grievance is this. All of us can take 3 attempts for mains. So, I am 2023 graduate of class 12. I can take mains in 3rd attempt. I took it in April. Correct, Malad? I am now entitled to take, 250,000 is the cutoff for advance. 15 lakh take mains. Out of that, they select 250,000 to take the JEE advance for the IIT. I am within that 250,000. That's what I've handed over to Lordship. 8 out of the 18 petitions. But because of this restriction, that in advance only 2, whereas in mains they can be 3. Because whatever number they choose, they should be doing from 3 or 2. But this argument that you will be studying, I'm studying for mains till April. I'm studying for mains till April. I only have to take 1 more exam. I'm sorry, my learning. It can't go up. And unfortunately, I have a lot of noise. I reduced it. So the point is that today.
No, but that if for main you are having 3 attempts and for advance 2.
That was precisely the question, Manoj, and I answered it by saying on the earlier. Manoj, please see, Manoj, the prayer clause 18/11/24. Manoj, that's the challenge before your lordships in this. Manoj, 18/11, your lordships have not considered and rejected on the ground that what happens is, Manoj, 2 years, 2 times, Manoj, the attempt is permitted. Now, Manoj, I don't get the choice, Manoj, my choice. So, Manoj, I will get admission in the engineering.
No, but why don't you restrict it even in mains to for 2?
That's why I'm giving that logic which your lordships were pleased to accept then. But the difficulty is that if I fail twice, but thereafter I settle down in whichever engineering mode I get and complete my engineering course. Otherwise, what happens is students don't concentrate on the study for first 2 to 3 years of engineering and they continue preparing for this entrance exam, hoping that they would get into IIT. So, Manoj, it can be 3, it can be 2.
No. So we did not interfere with that petition because it is to 2. So,